Hepinize akşamın bu saatine kadar bizi beklediğiniz
I would like to thank you for your patience and for attending this last session of the day. I am Refik Tiryaki, Energy Market Regulatory Authority. I'm responsible for Wind and Solar Energy Group. I'm the head of group. On behalf of my authority and myself, I would like to welcome all of you. This last session will be dwelling on the wind energy law and the electricity market law. I hope it will be productive both for the participants and the sector. And I hope we will give you the information you need and answer your questions in your head. We have 4 distinguished speakers who know both the theory and the implementation of this issue, of this topic. They will not be speaking in the order in the program, but we will put them in a different order depending on the topic and the relevance of the topics they will be discussing. First of all, Bekir Çorbacıoğlu will be speaking. He is a supervisory board member at the Turkish Wind Energy Association. From 2010 to 2014, he worked as an engineer at the Renewable Energy Department. Then from 2007 to 2011, he worked at the General Directorate of Energy Affairs, and today he will be speaking about the environmental impact assessment and the problems in this process from the perspective of investors. Now I would like to leave the floor to our first speaker. Thank you very much, Mr. Refik. I'm the only engineer on this session. Apart from me, other speakers are legal professionals, so I think I will be using a different terminology from them. As Akku Energy, which is my firm, I will be speaking about the investment process from the investor's perspective. I will give you our perspective on wind energy investments. My topic will be the problems about the environmental impact assessment. These problems are important both for the investors and from the perspective of legal professionals. Environmental impact assessment, then licensing, then development. The laws on these different aspects need to be considered together. They should be assessed together as a whole. And generally, in these different processes, there are legal problems. When the investment reaches a certain level, there may be some cases before courts about the environmental impact assessment by the members of the public or by the investors. And if this is the case, if there is a case before a court, then you have to start all over. And as the investors, we have to abide by the periods of time provided in the relevant legislation, the electricity market law, the environmental impact assessment regulation, and also the rules regarding development. We have to observe all these provisions in different legislation and organize them. All although it seems possible that all steps, necessary steps, can be taken within the given period of time, it may not always, we are not always able to do it on time. And what could be the primary reasons that we are experiencing problems in this process? I will give a sincere answer to this question for the wind energy investors. Increase of mechanic installed capacity or installed electricity capacity maybe give us an opportunity, and also the legal professionals are turning to us and asking investors why they did certain things in that way but not the other. The reason is that we have to complete all administrative allowance or permission steps within a given period of time, and while we are following these steps, we of course try to take the measures to prevent potential problems, but we can still come across unexpected problems. For example, there can be problems about ownership or problems about the delayed environmental impact reports, and as the amendment need for amendment increases, we also reflect these amendments on the environmental impact report as well. And the environmental impact actually is carried out separately on unit basis, area basis, by taking the opinion of all relevant public institutions. This is a detailed analysis. And when there's a request for amendment, we have to start all over each time, and we have to reflect those amendments. These amendments could be related to the selection of unit, changes in installed capacity, changes in wind characteristics, and as these changes occur, the amendments in the license and in the environmental impact report is complicating the process. And within a certain period of time, we have to complete the process of ownership. And if we fail to do so, then the legal professionals will also be telling about this. But in 5 years' time, if you do not get involved in the field, then you can lose all your rights, and your environmental impact report could lose its validity. It may not be valid anymore in that case. I will not be taking too much of your time. I will leave the floor to other colleagues, other speakers. Actually, these permissions that we need to take for our investments, the environmental impact report is selection of the turbine and all other steps that we have to take. When we are taking these steps, we are faced with time constraints. This is a reality, and of course you can apply for a time extension. This can also be the case, and the time given can be extended. As an investor, we need to be in close contact with relevant public institutions, public bodies, and in the event of a problem, we must communicate this problem immediately to the relevant officials or bodies. So, as far as we can, we are trying to abide by these time limits. And in terms of environmental impact, noise or proximity to inhabited areas, these different aspects should have to be put in a report, and we are doing our best to achieve this in time. And as far as the number of requested amendments is not very high, we can manage the time effectively. But when the number of requested amendments increase, we are having time problems with time. So I would like to thank you for giving me the opportunity. I would like to thank Mr. Bekir for his remarks. He said that there can be some problems in the coordination of the administrative processes. Administrative processes should be coordinated very well, otherwise there may be problems in the phase of environmental impact assessment. Our second speaker will be lawyer Arsin Demir. He is the founder of the Demir and Demir Law Office in Izmir and also an employee of this law office. He received training in English in the United Kingdom and graduated from Marmara University. And he is also the legal counselor of the Holland and Turkey Law Office. Today he will be speaking about the lawsuits on environmental impact assessment and his opinions on this. The floor is yours.
Thank you, distinguished chair, and I'd like to start by thanking TWEC for this importance that it places on the energy law and for the organization of such an event, of course. As a member of the Izmir Bar Association, as an attorney at law, I must say that there are court verdicts which can serve as an example regarding the EIA processes. Bekir Bey, he has his EIA and he's happy swinging it around, wiggling the report around. So happy EIA is here, the report and the approval is in place, but still he can encounter very different, unexpected challenges, legal-wise, law-wise. If, as an investor, he has obtained a no EIA approval, it can be objected to, taken to court. And, well, I'm saying Bekir, I think you're okay with me calling you with your first name. Okay. So if you have an EIA positive, it can still be challenged at court, again in the same administrative court in the same region. Then, as an investor, can he be immediately informed about such a case, such litigation? No, because the litigator might be the locals or the environmental, let's say, associations or societies, or someone who might have claims, who might claim that they have certain interests in such litigations. It's a case which is heard between these parties, not the investors. And as the investors, you might, maybe you don't believe what you hear, but it is so. If there is a sensitive judge, let's say, unless they don't inform you, you would not know about this, because these cases are filed against the governor's offices or certain other government bodies, and unless they summon you, call you, or invite you, depending on the authority, to take part in the court process, then you would be facing this in the future. Let's say, what you heard about this litigation, and what do you have to do then? You have to access to the administrative court file, have it scrutinized by an expert, of course, and then find out, not find out, but intervene with a petition to the court, and this does not make you a party to the court process. You become one of the interveners, like the governor's office or the ministry. You cannot object, you cannot take it to the higher court. So as an investor, you find yourself in a dire situation. There is an expert scrutiny, of course. That's a process. and there is a shortage of quality experts who are really knowledgeable about EIA processes, and the courts have difficulties, real difficulties, in finding EIA experts. If that's a forest area, you would need a forest engineer. If that's an agricultural zone, you need an agricultural engineer. And interestingly enough, if that's an area where you have a very curious species of animals or vegetation, then you would need a zoologist or someone else knowledgeable on those issues. But the courts just handpick a couple of mechanical engineers and environmental engineers, because those are the only ones they know, as the experts that take them sometimes to the site, maybe 10 minutes, 20 minutes, and that is how the expert report is issued. The expert report that will define your destiny, actually, the destiny of your investment, actually. And if that's the court case is against you, the court decision is against you, is that the end of the world? No, it's not. You have to make other applications to the administration. The administration will evaluate, and maybe they have a positive decision, and they issue another document for you, but it is time consuming. That's the issue, and then you might face another litigation as well. These trials are handled with the expedient trial process. I think this is important what we are talking about. And these cases, yes, are heard through expedient court processes. And when you have the EIA negative or EIA positive decisions, please check with the respective institution whether or not it is announced. If there's a problem with the announcement, then it might take you even 15 years. I mean, after 15 years, they might still take the matter to the court. The turbines were rolling for the last 5-6 years, and someone has filed a case at the local court, and the court did not say, come on, this case, the court said the turbines are turning, the plant is operational for the last 5-6 years, but the Council of State did not consider that enough of an evidence, and after some 6-7 years, a court case was filed about the running up an operational plant. There's a lot to say in this regard, and I don't want to steal from the time of my fellow speakers, but let me say this, that the biggest problem in the time ahead is to take into consideration the entire evaluation process in a cumulative manner. There will be some regional aggregations. Please consider the interaction with the neighboring wind farms, for example. How are you going to do it? On the basis of magnetic resonance, on the basis of noise or dust? How? Bird migratory routes? What are you going to focus on? The other peculiarities of the locality? There's a gap. Actually, there is not a gap, but no explanations in the legislation. If you work on the bird migratory routes, then you might be faced with a court case on forestry, for example, or vice versa. The EIA is like the heart of such projects, and when the heart stops, especially during litigations, when someone files a license cancellation case against you or expropriation case against you, EIA cancellation case against you, it's your heart. You receive sometimes permits or opinions from almost 45 institutions, and someone who just has this grudge against you can file any case at the court, lodge any sort of case at the court against you. But as long as you have a good EIA, a strong heart, beating in the behind, in the backstage. That is what's going to save you in these litigations. If you think in that region you believe that there's a risk of someone litigating you at the court, just keep in contact with the governor's office, the ministry. Just go visit them every 2-3 weeks. I mean, if you have that hunch, if you have that feeling that someone might challenge you at the court, so just keep the contact, shoulder contact, and just rest knowledgeable about the issue. Thank you. Thank you for keeping up with time. Allocated time is critical for us. Let me reiterate, our friends are keeping up with the time that we have allocated to them so that you will have more time in the Q&A session, questions and answers. The third speaker is Özlem Döerlioğlu Işık Sungur, attorney at law from Döerli Law Office as a senior associate. 9 Eylül University Law Faculty, that's where she graduated. And a double major she has in the management law. In France, she attended business school after graduation and succeeded in that program as well at the Ankara University. She focused her studies on the amendments on the legislation and the reflections of the amendments on the consumers law. That's her dissertation, PhD dissertation, still in the Izmir Economy University. She's a tutor in Yaşar University as well. She tutors on some legal matters. Özlem Hanım today will be speaking about the durations that are regulated in the legislation, the liabilities and obligations of investors, and what happens when those obligations are not performed, the sanctions, including cancellation of licenses and the remedies that are available in those cases. Özlem Hanım, the floor is yours.
Sayın Başkan,
Distinguished President, thank you. There are 4 parts of my presentation. First part about the wind energy situation in Turkey that was also touched upon in the previous presentations, in the previous sessions. The second part, we will go very fast. It will be about the electricity production generation alternatives. Then we will speak about legislation, durations, license cancellations, and the final part will be about assessment and results. The TWEC data from 2014 to 2018, we can see that while the installed capacity share of installed capacity was 0.8% in 2008, it has increased tremendously until 2015, and by 2023 we have an ambitious target in the wind energy sector, and we have only 2 licensed projects, licensed electricity generation and unlicensed electricity generation. I will not be focusing on the licensed and unlicensed projects. If you have any questions, I will answer, but I'm skipping that part right now. First of all, the relevant legislation, electricity market law, TWEC law, and the electricity market license regulation, and renewable energy law, and also we have the communique on wind and solar energy based preliminary license applications, and also another regulation on technical assessment of applications for wind-based electricity production, and also we have some other relevant documents. The process starts with development, then comes preliminary licensing and licensing, and the third step is financing, fourth step preparation for construction, fifth step installation construction, then acceptance and finalization. we should look at the legislation from two different perspectives: before the law number 6446 and after the enactment of the law number 6446. With the enactment of the law 6446, now we have two different stages: preliminary license and production license. First, for preliminary license, you have different obligations, and in the second stage, production licensing, you have different obligations. In the preliminary licensing phase, we call it the pre-construction phase. You have system use agreement and the allocation of the settlement area and many other steps that you need to take. In the law number 4628, you needed to take the permissions before the construction began. But with the enactment of the law 6446, the new law, there is a transition process that is stipulated by this law. Temporary article, provisional article 9, it says that during the construction phase, if the obligations which should be in place, which should be fulfilled for the construction, and if these obligations are not fulfilled, then an additional period of 6 months can be provided. Except for force majeure. If you do not carry out your obligations, then your license may be cancelled. This is the provision in the law. What are these obligations that you need to fulfill within a period of 6 months? This is regulated by provisional article 15. You have to solve problems about the development plans, about ownership and rights of use, and also the technical interaction permission that you need to take. You have to complete these within a period of 6 months. And in today's legislation, these durations have changed. First of all, we have the preliminary license applications preparation phase. You need to make measurements for at least 1 year during this phase. Then the preliminary licensing phase, which is 24 months, and after the preliminary licensing is granted, then you need to provide environmental impact assessment within 90 days and the technical interaction permission within 180 days. Then the license application, you will make the license application within the duration allocated for pre-licensing phase, which is 24 months. Then licensing applications and their assessment, you have there is 10 days for the assessment by the authority, and you have to make up for any deficiencies within 15 days, working days. And the assessment of the licensing applications, if you have fulfilled your obligations, then the your licensing application will be assessed. However, that the licensing application is under assessment doesn't mean that you will certainly be granted the license. And the licensing applications will be completed, finalized within 45 days. The preliminary licensing and licensing durations will not exceed 24 months. It can be extended up to 36 months maximum, depending on the type of your resource and your installed capacity. And the license will be provided for a minimum of 10 years and a maximum of 49 years. The assessment of the preliminary license, the application for a preliminary licensing, assessment of the application, and the finalization of the assessment. You need to take into consideration the minimum capital, the guarantee letter, and the amendment of the main agreement, and also you need to pay the fee for preliminary licensing. Then in 10 working days your application will be assessed and the preliminary licensing will be provided if your application is deemed appropriate. We all know these steps that need to be taken, so I will go very fast. The first application for 2015 were between November 2013 to March 2014, and according to the legislation, on the first 5 days of October each year, applications will be made. But of course, in practice, there are some problems regarding this duration provided in the legislation. Measurement of wind, it should be at least a 1-year measurement within the last 3 years, and there should not be more than 20% loss of data. The bank guarantee letter will be obtained by the investor, and also the guarantee will not exceed 5% of the total amount of investment. The minimum capital increase, then comes the TWEC and the contribution. What are your obligations during the preliminary licensing phase? First of all, you will complete the procedures for the ownership of the facility. Then the development plan will be approved. You will get the approval for the preliminary project approval, actually, and also you will make your applications to TWEC and other relevant transmission companies, and the environmental impact assessment that you need to deal with within 90 days of time, and the technical interaction permission you need to take within 180 days. If not, if you fail in this process, what will happen? Then your preliminary license will be cancelled, and within this period, if you do not carry out your obligations, which means if you do not provide the necessary reports or take the permissions within the determined period of time, your preliminary license will be cancelled, and the guarantee letter will be recorded as revenue if your preliminary license is cancelled according to Article 45 of the law. If you fulfilled your obligations, then you will continue with the stage of licensing application. There is one point that you need to be careful about. You have to apply for licensing during the period, during the duration of a preliminary licensing. And if you fail to do so, then then your obligation will not be fulfilled. I mean, the authority will assume you haven't fulfilled your obligation. And if you do not fulfill your obligation, then your application will be rejected. But if you fulfill this obligation and make your licensing application within the period of time allocated for preliminary licensing, then you will be granted the license. Then your application will be assessed, taken under assessment. The licensing process, here you can see the construction durations according to the legislation. Now I will continue with the license cancellations. If you act contrary to the articles of the law, articles of the legislation, and if you do not establish the facility within the construction duration granted to you, and if it is detected that it will not be possible for you to complete construction within the remaining time, then there will be cancellation of licensing. What are the sanctions in this case? You may either be granted administrative fines, you may have to pay administrative fines, or your license may be cancelled. In the legislation, cancellation of license is mentioned in 3 different provisions. One of them is if you provide false documents, your license may be cancelled, or if you do not fulfill your obligations, it says in the legislation, then your license will be cancelled. In the event of cancellation of license, is everything over, or is there anything else you can do? First of all, you will apply to the administrative court to file a case, or you will file a case against the sanction decision. And if you are to file a case, then you can file a case for cancellation. If you file a case for cancellation, then the decision of cancellation given by the authority should be against the provisions of the legislation. You should try to prove that the cancellation decision is against the legislation. This is the only way you can go. And I said you could apply to the administrative court. You can apply in 60 days time. And what will your demand be? We will demand the cancellation decision to be revoked, and we will demand within 60 days to be re-granted the license. So what may happen? Your case may be approved by the court, your case may be rejected by the court, and in that case you may have to go to the court to file another case. And for the case to be opened, to be filed, you have 60 days at the administrative court. Based on what justifications can you file a case against the cancellation? First of all, if you can claim that there's a problem with the authority, the authorization of the institution which cancelled your licensing, and also about the reason for the cancellation, you can file a case at the administrative court. And in that case, the cancellation decision may be revoked. And it is not sufficient to file a case at the court. In parallel to that, you should also make a request for the process to be revoked as well. And if there is a possibility that irrevocable damage may come up in that case, then your request may be approved by the court. But you may not receive a compensation if you request a stay of execution and if it is approved. You don't receive a compensation for that. The legal outcome of the cancellation of licensing. What happens from the legal perspective? You cannot apply for a license for 3 years. You cannot be granted a license for 3 years, and you cannot have a share in the licensing legal entities applying for a license for 3 years. This is the legal outcome of the cancellation. And what about the economic outcome of the cancellation of license? Also, it was mentioned by TWEC as well, the economic outcome. There's a risk for many projects currently. Their licenses can be cancelled. So what will happen if there's such cancellation? We have wind power plants with an installed capacity of 3,116 megawatts. So 78 wind power plants are under risk for cancellation of licensing. So what will happen if these wind power plants do not start their operation, do not become operational? We will have a hard time reaching 2023 goals, and we will be deprived of a 6.5 billion euros of investment in that case, and we will be deprived of an investment which could help us close the current account deficit of $1.3 billion. And as a result, what should we do? These projects belong to all of us. Therefore, both the administration of the project and the investors have a lot to do, have a lot of duties they need to fulfill. First of all, the investor should fulfill all his obligations in time and precisely, and they should remember that they need a good team if they want to succeed in fulfilling their obligations. and also interinstitutional communication and workflow should be ensured, and the necessary measures should be taken immediately. Also, you should design your projects in a way to be compatible with the legislation enforced in effect. Özlem Hanım, Ms. Özlem provided us information about the whole process, the durations, applicable durations, and the steps that need to be taken for licensing, and what steps you can take if your license is cancelled. Now the final speaker, Süleyman Boşça, will take the floor. He is the president of the Energy Law Research Institute. He is also working as a lawyer at the Ankara Bar Association. He is a graduate of Ankara Faculty of Law and also has an MBA. And he has certificates in energy law, and he is currently working as the president of the Energy Law Research Institute. Apart from this, he is board member of other institutions, and also he has other responsibilities in numerous other institutions related to energy. Süleyman Boşça will talk about force majeure in cancellation of licenses and which justifications may be valid in that case.
Başkan, teşekkür ediyorum.
Dear Chair, thank you, and dear participants, thank you for bearing with us after this two-day marathon, and it's the final address, and you have not left us alone in this session, nor you haven't left me alone in this speech. I have a curiosity among you. Are there any investors, licensed investors or pre-licensed investors? Yes, there are some. So what I'm about to tell you relates to you, mostly. We have the law 6446, and after it was enacted, I've been representing many clients, and most of them had gone through a certain shake-up period, anxious period, because the provisional Article 8 and 9 of the law concerned had certain provisions requiring the licensed companies, license holding companies, if they have not completed the construction process, with some 6 months of additional and another 6 months of additional extension if they have completed their construction processes. And the amendments have defined at a later time what those obligations were, and those obligations have to be performed within a period of 6 months. And in cases that they fail to do so, because of, with the exception of force majeure, then their licenses would be cancelled, annulled. And the regulation also provides us with some reasonable reasons which don't arise from the investors' side, and that was what the investors were anxious about. More than, or rather than, delays arising from the administration or public or government bodies, they had question marks as to whether this would be a force majeure or not. If that was a force majeure, then there would not be a problem, and they would avail themselves of this force majeure. But if that would be accepted as an reasonable condition, then they would be faced with, they thought, the cancellation of their licenses. Now let's take a look at force majeure applications as applied by the decisions of the Council of State as well as by EMRA. Force majeure is regulated in the license regulation, and when we look at the regulation, we see that what is regulated is the conditions for force majeure, and the party who is affected by this force majeure is expected to have taken all the precautions, have taken into consideration, have taken all the care. acted in due care and due diligence, and still accordingly that event of force majeure has to be unforeseeable and inescapable, preventing the affected party from the performance of its obligations. So there is a distinction between the reasonable reasons and the force majeure, and that distinction actually leads no place else than confusion. The regulation makes a list of cases of force majeure, and the interpretation constraints lies therein, without limitation to natural disasters, epidemics, war, nuclear and chemical emissions, fallouts, mobility, riots, etc., and acts of terror, sabotage, lockouts, etc. So, but where our focus lies is the licenses and the pre-licenses of the investors, and during these processes they have to obtain numerous licenses and permits, and what would the impact of these would be on the investments. That's where our focus lies in, and whether or not these cases would be considered as force majeure, or for example litigations, EIA litigations for public interest, for example, are these forces majeure or not? That's what the discussion is about. Plus, when the force majeure materializes and you have the license holder, he cannot just escape. Here's the force majeure, I have no responsibilities. No, he has responsibilities that he has to live up to. Otherwise, the investors wouldn't be able to avail themselves of the force majeure. So the quality, the nature of the force majeure and the date of commencement of the force majeure, as well as its impacts on the legislation and the performances arising from the legislation, should be incorporated into a petition which should be forwarded or submitted to the respective authority, the institution, in 60 days, starting from the collection of all the documents. The institution has to make its decision about such an application before coming here. Yeah. The sanction on forces majeure, or the circumstances, there are precautions to protect the investors, and the first and foremost of these precautions is the force majeure, because apart from force majeure, the investors have no remedies or no regulations that would save them from license cancellation, because you are generating electrical power. That's your field of activity. That's the activity you carry out, and for the investors, this should not be a sporting activity. They should have certain guarantees to satisfy. The pre-license duration shall not exceed 24 months, with the exception of forces majeure. That's the license regulation. How about reasonable reasons? Why are not they here? Because this is the pre-licensing period when you contact government bodies. Any delays in obtaining forest permits or other permits and licenses, for example, is that any delays? Is that for force majeure or not? Well, here we see that all these concerns are groundless, and forces majeure during the license process now. They are considered as reasonable reasons which do not arise from the investors. And the amendment or modification of licenses on grounds of the modification of the installed capacity of the generation plant. There is a 90-day period, and the exception is the EIA document, which has to be submitted to the administration in 90 days, then a cancellation of the EIA is that the force majeure, because there is the expression with the exception of force majeure here. Taking a look at the practices, the litigations, expropriation litigations or EIA litigations are considered. We see that they are considered as force majeure, and this is relieving for the investors. Still, there is room for the consideration of the board. This is also something which makes the investors anxious, because they fail to see the legal security, or they fail to see the future clear ahead. And once that clarity has gone away, then the investors become anxious, but they have no other choices than going on with the investment under these circumstances. Özlem Hanım has talked about taking the investment as revenue by the state, etc. If the application is rejected for reasons other than force majeure, then the bank guarantee, is considered as revenue or registered as revenue. In terms of returning the letter of guarantee in license applications, again, the letter of guarantee is not provided, etc., with the exception of force majeure. Then again, in the provisional Article 9 of the law number 6446, the law provides explicitly and expressly that legal persons and their licenses who fail to perform their liabilities with the exception of their obligations, with the exception of force majeure, their licenses will be cancelled. This is the expression in the law, and in that case you are expected within reasonable time to address related bodies with the documents concerned. And if you have done your application as such, the delays arising from the government side are considered as force majeure. And also the decisions of the Council of State, taking them into consideration, we see that delays arising from public institutions are considered as force majeure, but still the decisions by the Council of State are within the framework of previous regulations, previous legal arrangements, where the government bodies and delays arising thereof were considered explicitly as force majeure. So the approach to follow would be no different than this one. As a conclusion, the very first amendment, we think, should relieve such or rectify such confusion, do away with it, and especially focus on the delays arising from public bodies, and the litigations that are against public bodies and that have an impact on the investment should be considered as force majeure. So the amendments should focus on these issues and clarify these nebulosities. Thank you for bearing with us once again. And if you have any questions and answers, we'll be most happy to respond to them. Thank you, Mr. Bohça, for these valuable pieces of information about reasonable, rightful reasons and force majeure, and thank you for sharing your experiences and knowledge with us, as well as your recommendations regarding the legislation. So this marks the end of the session where we have the speakers. We still believe that we have enough time for questions and answers, if there are any. Do you have any questions or comments regarding their presentations? If there is any questions? Yes, I see only a couple of hands. Let's start with the first hand. Please introduce yourself, the company, your name, and who you are addressing. Name's Mustafa, Arı Asmak İnsan Company. I have this question to ask. In EMRA, let's take the example of Department of Expropriation, and we have not received a response. The Electricity Market Department says that they are still waiting on a response from the other department. For example, we have sent this letter to the Electricity Market Department, and they respond to you that they are waiting for the response from another department, and it's been 12 months, a year, 2 years, and each time we call them, we either cannot find the expert or the specialist responsible for this issue. That's what happens. I'm not complaining, but this is what happens. Is this considered as a force majeure? And then if there is a time given, a duration given, then it is given retrospectively. So the time is due. There are many examples as such. I think everybody's clear about this question, and I am happy, most happy, if any of the lawyers could respond to this. Which one of you? I think Süleyman Bey, it relates to you most, huh? Well, as I said in my speech, your example is about the internal communications of the government body, and that would change nothing. These things happen, and they should be, within the framework of my speech, should be considered as force majeure, and the duration of the delay should be added up to your duration, and there is a Council of State decision. A decision by the Council of State. There's a license cancellation, and the Council of State receives this application, administrative application, that it rejects. And then after the decision of the Council of State, there's an additional duration given. Then that duration does not equate the time lost during the application, and there is another administrative application. There's another application upon the rejected application, and makes another decision. The Council of State gives the investor the duration that they request, the time lost, back. So I think it should be considered as a force majeure. Yeah, thank you.
ederim sorunun cevabı alınmış.
I think you got the answer to your question. Another question. Ahmet Çiçekçi, Orta Doğu Group. My question to Mr. Refik. On November 2nd, a license regulation draft was published on the website about cancellation of licenses. My question, as an example, I will give an example of a natural gas plant. Will it be possible to amend the license of the wind power plants? As far as I'm concerned, your question is about the draft regulation on the website of the institution, but we are not clear about your question. Could you clarify it? About a renewable energy source. The change of a resource to be used. When we say the change of resource, is it a change from a renewable energy source to a fossil energy source, or is it possible to change from a fossil energy source to a renewable energy source? Will we be able to amend the license if we change the energy source? I do not remember the details very well, but basically, if a license is granted for a renewable energy source, then an additional, without the use of an additional connection capacity, if another plant, another source is established, for example, if a solar energy plant is established on a dam, or if in expropriated areas within the area of a wind power plant, if a solar energy plant is established. This is what that regulation draft relates to. and it is only a draft, and that is why it is not a final document, and we cannot say it is approved. It is just a draft which invites discussion, which invites negotiation on that topic. But based on the opinions from the sector, the draft may change, so please do not consider it final. Any other questions to the panel speakers? Okay, there's one more question.
Merhaba.
Melda Aslan from Reconsult. I have a question to Mr. Süleyman, but Mr. Refik may also answer to a part of my question on behalf of his institution. Mr. Süleyman mentioned EIA and other cancellation cases, and he said new arrangements, legal arrangements could be made regarding the cancellation cases. And under EIA, if there is no problem, but if third parties file a case of cancellation, then your project will stop, will be interrupted. They know that if they file a case, your project will be interrupted. And unless before the case is resolved, you do not know whether the project will end up or continue. But there will be a stay, the project will be interrupted. But it may be obvious that there are problems with the project, and according to the annexed list of the environmental impact assessment regulation, we have made an investment in a risky field. And although there is no specific problem related to that area initially, a problem may come up. Either there has not been a sufficient assessment made, and that is why that area was not considered risky and was later found to be risky, or maybe the situation changed and the area became risky. In that case, if a case is filed and when the court asks your opinion, will we take the environmental impact assessment as the basis? If it is taken as the basis, I mean, if in the environmental assessment report the area was not considered risky, then what will the decision of the court be? Süleyman Bey will answer your question. In cases of cancellation based on or against the environmental impact assessment, the court makes the final decision. And for the EIA, if the investment was in a problematic or risky region, what would the result be? It depends on the verdict of the court. If the court makes a decision for cancellation, then in that specific area no investment can be made. Therefore, these additional durations that we have mentioned, these extensions we have mentioned, these are these additional times are the times that will be granted to the investor in case of force majeure. Therefore, these additional times will not be granted in the case that you mentioned. Let me also try to answer your question. Mr. Süleyman gave a very precise answer. I agree with him. But as an investor, if you're working with the public sector, then any step you take can bear a result in your favor or not, or vice versa. And in EMRA, in the Energy Market Regulatory Authority, we consider the notifications to be accurate, and we consider them in this process. But when an investor makes a declaration, a statement, this declaration should be accurate. If they make false declarations, then the application will be rejected. So the declarations may bear legal results, legal outcomes. However, However, the issue of force majeure is very sensitive, and it should be considered individually in each and every file, in each and every case. So I cannot give an answer, a general answer. We need to consider that specific file, that specific case separately in order to solve this problem. I believe there are no other questions. So, okay, there is one more question. Thank you very much. Lawyer Kasım Balcı. Our colleagues made the necessary explanations. We have many problems regarding the cases before courts. And I would like to explain the problems we have experienced very briefly. The problem here, in my personal opinion, stems from the legal system. And sometimes the judges may not have the required know-how, and they totally depend on the expert reports without any technical knowledge themselves. There is a communique of the Environment Ministry regarding the EIA positive decisions. This communique is used in terms of problems regarding the EIA positive. I will be asking a question about this. EMRA, is there any plans for the Energy Market Regulator Authority to issue a separate communique, or will they continue to rely on the decisions of the Council of State in this field? As far as I'm concerned, there is no work towards issuing a communique related to the legal aspects in this field. With your permission, I would like to close the session. I would like to thank both the speakers on the panel as well as the participants. I hope we could give you the information that you would need in the sector. Thank you very much. Have a good evening.